Washington, D.C., and his wife is also a lawyer. I have told you all in different sermons, if I ever get in trouble, I can call him, his wife, or our mutual friend, Daryl Taylor, who's well, Daryl turned in his law license, but still his wife is a judge. So if I get in trouble, I know what to do. So, Brother Richardson, go right ahead.
Thank you for the introduction, Ricardo. It's good to be back. And thank you for inviting me to a part two. I guess, which means I didn't bore you too much on part one of this. I'll call it a Zoom seminar, if you will, and hopefully, I accomplished the goal to sort of make simple something or a topic that sometimes can be convoluted and sort of confusing because there's so much information out there, misinformation, and some of it seems very complicated, lots of legalese. But when you break it down, it's all very, very simple. And so I look for the opportunity to communicate to each of you, a topic so that you can walk away from this sort of having a better understanding of in this instance, trust, but overall just how to better prepare for and plan the transition as it affects your estate. So part one, we talked with a broad stroke about wills, trusts, powers of attorney, and today we're going to really dive into trust. At the end of the last session, or the first session that we had, there were a number of outstanding questions about trust and how they work and were they necessary. And I had suggested that we have a separate conversation about that because I do know that people throw that term trust around a lot, and you're wondering if you're missing out if you don't have one, and how do you set it up, and is it complicated, is it expensive, what goes into setting it up, and is it helpful, is it useful to me? So I'm hoping that we can sort of scratch that surface. But for those of you who didn't attend the first seminar, again, this is really about estate planning, about having the documents that you need in place to help you manage your estate and then dispose of your estate in the most streamlined way, effective, and in the manner that you prefer. And so we talked about using wills effectively and the role the will plays for passing on assets after you pass away to your legatees or to your descendants, or people you choose to leave property to. We talked about powers of attorney and how powers of attorney work to help you have somebody in place to manage your affairs while you're living. And if you're in a situation where you find that you are unable to control and manage your assets and your affairs, and how you can use that document to basically give authority to someone to help you keep things going while you're incapacitated. And the trust is another document in that trifecta there that has a lot of power and it's a lot of usefulness. And so I wanted to talk a little bit about it. What is a trust? And so a lot of definitions out there, but I just want to make it very simple. A trust, it's a legal entity. Okay, it's a legal entity that has at least three parties, right? You have a grantor, you have a trustee, and you have a beneficiary as part of that legal entity. And the purpose of that legal entity is to hold and manage assets for the benefit of a beneficiary or a number of beneficiaries. What exactly does that mean? That means that you take a dollar and you want that dollar to benefit a third person, you can put that dollar in a trust for that person's benefit. Okay, and I'm of course using a dollar as an example, but you can put anything into a trust that is an asset if you want that asset or those assets to benefit a certain person. Okay, so why even go through this? If you have a bank account, if you have a house, why go through the trouble of putting together a trust? I'm pretty sure that my loved ones eventually will get the money or get the house. Well, things don't always work out like you hope. Okay, and so the trust gives you the ability to put a plan in place, if you will, to identify exactly what types of assets or property you want to benefit a specific person. Okay, so again, just to reiterate, it's a legal entity. There's a grantor, there's a trustee, and there is a beneficiary. Okay, grantor, trustee, beneficiary. Now, you set the trust up. The trust can also own and hold property. So it can hold and own any type of property that you as an individual can own or hold. Okay, so cash, antiques, promissory notes, real estate, CDs, life insurance policies, anything that can be considered an asset, a property, can be owned and managed within a trust, just as you would if you were an individual. Okay, so I like to call a trust a separate person, because that really is sort of the way it works. You're taking the property out of your individual name and you put it in the name of the trust, and then the trust operates independently in a way. Okay.
Excuse me. We're not. I just want to make sure we're still seeing your cover slide. Were you advancing, or you still want to be on that one?
Well, this is I will absolutely. I appreciate you reminding me there, because I got on a tear.
Yeah. You may need to go back and change that view there, and there you go. Thank you.
Mm-hmm. All right. Here we go. So that's a general overview of what we're talking about. Okay, what we're talking about is this legal entity. This legal entity is set up so that it can hold property. That property is held for the benefit of another person. So there are various examples of how to set it up, but generally, you're going to be dealing with two types of trust: either a revocable trust or an irrevocable trust. All right, a revocable trust or an irrevocable trust. The grantor of a trust usually is you, right? So you are sitting around and you're thinking about how to dispose of your assets. How do you want things to be handled and managed when you're not able to do so anymore, if you passed away? And you then take stock of what you have. You can distribute any type of asset into the trust. The trustee is then instructed to manage and hold and distribute that property for the benefit of a person that you have identified as the beneficiary. Okay. So a good example is a grandparent, who, let's say, is sitting on a good amount of money and wants to make sure that a grandchild is taken care of. And the grandparent may come into an attorney's office and say, well, I want to make sure that my grandchild is taken care of, but when I pass away, I'm not quite sure how my estate's going to go, but I do know I want to make sure that there's enough money for my grandchild to use, and she can use for education, or she can use for her wedding, or she can use to start a business, or whatever. But I do want to make sure that that money goes to my grandchild. And so you can use the trust. The grandparent can use the trust and say, I want to set aside, for example, $100,000, and take $100,000. I'm going to put it in trust, and that $100,000 is going to sit there. It's going to gain interest. It is going to be invested, and it's going to grow for her benefit, and not for the benefit of maybe my spouse, maybe not for the benefit of my other children, but this particular grandchild, right? Once I get this money and I fund this particular trust with that money, everybody's on notice that this money is set aside for that particular grandchild. And so that's what a trust can do. A trust can help you segregate assets, and it can help you make sure that certain people that you want to benefit are benefited, right? The trust document, the trust paperwork is almost like a contract. So it's a contract between you as the grantor, the trustee, who is the sort of independent person whose job it is to receive the money, manage the money, protect the money, and then distribute the money for the benefit, not of the trustee, but for the benefit of the person who is named as the beneficiary. Okay. So I want to stop there, just ask if anybody has any questions about that, because everything else you talk about with trust sort of goes back to that understanding of how a trust works. What is it? How does it work? Who's involved? Okay. So before you get into the types of trust and, expense and, when do you set it up, et cetera, you got to understand the basic fundamentals of what a trust is. Or are there any questions? If so, let me know.
You
I
may
did have a
unmute.
question.
Go ahead. You can unmute, or you can put your question in the chat room. Deacon Veronica, go right ahead.
Okay. Can the trustee and the benefactor be the same person?
So usually when you start out with the trust, the answer, yes, they can be the same person. May not be necessarily what you want to do. And some states, depending on where you set your trust up, may frown upon that because you sort of merge the two. But generally, when you first started, you start a trust. Let's talk about a revocable trust. If you set up a revocable trust as an individual during your lifetime, usually you're also the trustee. Okay, so usually what you'll find is the grantor and the trustee initially are the same person. And then there's a different person who is the beneficiary. So if you are also the beneficiary of the trust, can you do it? Yeah, initially. Does it help you? I'm not sure that it does. Okay. And so I think that'll get into the discussion about why are we doing this? Why would you set up a trust? If it's a situation where you are trying to just benefit yourself, you may not need to, utilize a trust. Okay.
Another question. My question is, if I want to name more than one beneficiary, do I need to have more than one trust?
No, you don't need to have more than one trust. You can. And that's the thing about the trust. The trust can be as simple as you want. It can be as complicated as you want. I've seen situations, for example, where there is an umbrella trust and the beneficiaries of that umbrella trust are 5 mini trusts. Okay. So imagine you have 5 grandchildren or 5 children with families, right? And you have a trust 1 for son 1, trust 2 for daughter 1, trust 3 for son 2, et cetera, et cetera. So you could do it that way, or you can have a trust that says, I'm setting aside this amount of money or this property held in trust by my children, my 3 children. Okay, so you got multiple beneficiaries. You have one trust, one property. Maybe you have a 4-unit apartment building that, you're renting out, and it, throws off a couple $100 a month in rent, and you put that in the trust, and, those 3 children are the beneficiaries of that income. Okay, so trust can be as complicated as you need it to be, or as simple as you need it to be. So the short answer is yes, you can have multiple beneficiaries of a trust, or you can separate and create new trusts for each beneficiary. It does become a little bit more expensive, right? The more paperwork you do, the more expensive it is. And that's just the way it is. So there needs to be, I think the more complicated it is, then it has to be a really good reason to make it complicated. And there are reasons. So, but yes. But does everybody sort of understand what a trust is? The three people who have to be involved, the grantor is the person who sort of puts the money or the assets into the trust. Then the trustee, who is the person who sort of owns or holds that money for the benefit of the third person, who is the beneficiary, or multiple beneficiaries.
I see
Chip,
Marie.
got two more questions. Sister Marie Gibson, go ahead.
Okay, go ahead.
Good evening. I'd like to know, when you have a trust, would the beneficiary have to pay taxes for that trust?
When you
Or
are,
gift,
I'm sorry, a gift tax? So
a
so
gift
yeah,
tax or any monies, would it cause the person to have to pay
no,
something?
no, because when you set up the trust is, again, and I'm going to, again, I'm going to get into a little bit about the difference between revocable and irrevocable trusts in a minute, but we're going to, primarily when I'm talking to you today, usually I'm talking about revocable trusts, and that'll make a little bit more sense in a few minutes. But when you set up the trust, and let's say you put, $10,000 in the trust, that hasn't gone anywhere. It has, I take that back. It hasn't gone to the beneficiary yet. Okay. So it hasn't been a distribution. It's in the trust. And usually people put a trust in place so that it can start operating at a later date. Okay. It's not always the case, but often when you're dealing with estate planning, you're usually using this document, just like a will. You're usually using this document to set up a trust so that in the event that you have passed away, then the trustee knows what to do with this property at that time. So there hasn't been, when you set it up first, there hasn't been a sort of any type of distribution made, so there wouldn't be any tax consequences to the beneficiary. Okay, and usually when people inherit through the probate process, they're doing that tax free, usually. Okay, so you always want to check with a tax advisor with respect to your specific situation, but you're usually not getting taxed on what we call inheritances. And usually what we're talking about, for the most part, when we're talking about trusts here, we're talking about trusts that are being utilized for the benefit of estate planning. Okay, so taking assets and income from one person's estate who has now passed, and then passing it on to beneficiaries. Okay, so you're still talking about that sort of no tax zone. When you get into irrevocable trusts, that's a little bit of a different animal with respect to the tax consequences. But if you are making income, I talked a little bit about that as an example, that 4-unit building. If you have a 4-unit building and you're generating income, and you put that building in the trust, you still have to pay taxes on it, right? Because it hasn't gone anywhere. It's still in the trust. You still own it. You're still alive. Okay, and your beneficiaries of that 4-unit building, when you pass away, they get that 4-unit building. At some point, they're going to have to start paying taxes on the income as well, right? They may not have to pay taxes on the building, but that depends. But they certainly are going to have to start paying taxes on their income once they become, sort of the beneficiaries of that building and its income. Okay, I always tell people the government's going to get their money, right? Unless there is some specific statute out there that says, okay, this type of transfer of wealth is not taxed. Usually there's going to be a tax somewhere. Now, when we get into estate taxes, and this is not a seminar on estate taxes, from the federal standpoint, you have to be passing along a fairly large estate before the government starts to tax it. Congress has done a really good job to protect a lot of those transfers from estate taxes. Now, each state, Virginia, Maryland, DC, they may have inheritance taxes depending on the state you're in. Okay, I know DC does not. I think Maryland does. I don't recall about Virginia, but I don't think they do either. But you have to look at your specific set of circumstances when it comes to taxes. You don't want to, be in a situation like this sort of seminar and try to apply your tax situation to what we're talking about in generalities. Okay. But to answer your question, when that trust is set up and the money is put into the trust, while you're still alive, you are still responsible for paying taxes as appropriate on that property or income. Okay, but not the beneficiary. The beneficiary is not responsible for it. Okay.
Okay. All right. Thank you.
Mm-hmm.
I'm going to read this question from the chat room. If you put assets in a trust, does it have to be liquidated if you go into a nursing home?
No, not right away. Okay, not right away. And that might go a little bit beyond the scope of what we're doing here, but it's relevant. And I do a lot of guardianship, conservatorship work, and also estate administration work. And what you see is, when a person goes into a nursing home, there's a question of payment, right? Is there long-term insurance in place to pay for the nursing home stay? Or is this person Medicaid, not Medicare, but Medicaid eligible? Or does this person have sufficient assets to go private pay, right? And pay the $3,000 to $6,000 per month that's required to cover the cost of nursing home care. Again, each individual situation is going to be different here, okay? So let's say this person went into a nursing home, but they had set up a trust, right, for the benefit of someone else. So the real question is, can a creditor attach the money that's in that trust, right? Because you're trying to put that money in the trust so that it goes to my granddaughter, for example, so that I don't have to pay the nursing home out of this pile of money. Well, when you're dealing with a revocable, trust, and this is what these revocable trusts, it's still considered your property because it hasn't been distributed to the beneficiary yet, right? So what happens is Medicaid is going to look at all that. If Medicaid thinks that, okay, we shouldn't be paying for this nursing home stay if you have resources sufficient to use for your nursing home stay, and they're going to probably count the money in that trust against that at some point. Sometimes Medicaid is slow to act, okay, but at some point Medicaid is going to come back and try to get attach and lien to the estate. So when you're dealing with a revocable trust, and I guess it's a good segue to go into what the difference is between a revocable and an irrevocable trust. The revocable trusts are subject to creditors' claims, right? And so when you go into a nursing home, that nursing home becomes a very serious creditor. Do you have insurance to cover it? Are you going to use your money to pay for it? Or are you Medicaid eligible? And as you know, in order to be Medicaid eligible, that you can only have a certain amount of money in your bank accounts, et cetera, to remain Medicaid eligible. And if you also have a residence in the community that, where a spouse doesn't live, Medicaid is probably going to try to attach that at some point. So some people may say, okay, let me put this house in a trust for my children. So, I live this next 5 years in a nursing home. Medicaid knows about that house. And there probably is going to be a Medicaid lien coming at some point to try to get their money back for whatever they pay in that nursing home. So again, this goes beyond the scope of this, but I will say that a revocable trust is not going to help you avoid paying for that nursing home. Okay, so there are two types of trusts generally that for our purposes. There are a lot of different types of trusts, but for our purposes, when you're talking about estate planning, et cetera, and property management and asset protection, because all this is related, then you're dealing with two types of trust. You're dealing with revocable trusts and you're dealing with irrevocable trusts. And revocable is just what it sounds like. You give and you can take it back, right? So I'm setting up this trust while I'm alive because I think this is how I want things to go when I pass away. Next year, things have gone sour. I don't like you anymore. I'm revoking the entire thing. Okay, you can do that with a revocable trust. Okay, and that's why it's called revocable. You can change your mind. You can change the terms of the trust while you're living. You can change the trustee. You can change the assets in the trust. You can do all kinds of flexible things with a revocable trust while you are living before that trust really starts to operate after you have passed away. The same is not true with an irrevocable trust. Okay, an irrevocable trust is a complete separate entity from you that also takes full ownership over whatever asset you put in it. Okay, and so it also has a grantor, also has a trustee, it also has beneficiaries. Okay, but what you'll see, and I think that most people hear about irrevocable trust when they hear about congressmen who have been elected to office, and then they say, okay, I'm going to put my my brokerage account in a blind trust. Okay, that way there's no conflict in me, voting these shares, and no undue influence on how I vote here and there. I no longer have any control over this brokerage account or these assets. I put them in an irrevocable trust. What does that mean? That means that they have established a trust that cannot be changed without dire consequences. Okay, so again, using the brokerage account as an example, they would do an assignment. They would, after setting up the trust and making sure that it's clear on the face of the trust that this is an irrevocable trust, and a independent trustee, independent meaning that trustee can't be the grantor. Okay, with the revocable trust we talked about, when you first set it up, you can also be the trustee. Okay, but in the irrevocable context, there's an independent trustee, and that independent trustee has sort of a broad set of responsibilities and obligations and authority to manage those assets for whoever is designated the beneficiary. And you have put your money or your brokerage account into that irrevocable trust, but that's it. You have stepped away from it. You have no control over it. And therefore you're not getting taxed on it. The creditors can't touch it. There's all kinds of security in an irrevocable trust. Of course, the irrevocable trust is more expensive to maintain. Someone has to pay that trustee. The trustee is probably getting paid out of the assets in the trust. So it's a different entity. And again, it goes also beyond the scope of what we're talking about when we're talking about just basic estate planning. Irrevocable trusts do exist though, and they can shield assets from creditors. They have to be set up properly. There are certain tax consequences, tax savings, if you will, as well, in utilizing irrevocable trusts. And if you have a financial advisor, you can talk to them and see whether or not that type of trust is what you need when you're doing sort of the more high-level estate planning, where you need to be getting money out of your estate and those types of trusts can be useful there. Okay. But in the revocable context, the revocable trust, you can make changes for as long as you're living. And then once you pass on, that trust becomes irrevocable. No one can then make any changes to that trust after you have passed away. So at that point, the revocable trust becomes almost like a will. Okay, and we talked a little bit about that in the last time. What does the will do? The will sort of dictates who you are, dictates who your heirs are, and it dictates how you want your property distributed. Well, once you pass away, that revocable trust that you have put in place becomes irrevocable, and it starts to act like a will. There's a trustee in place, and that trustee has a set of instructions, and that trustee is going to distribute the assets per those instructions. Okay, so that's the main differences between a revocable trust and an irrevocable trust. Does that make sense?
Mr. Richardson,
Yes.
good evening, sir. What I heard you saying on a revocable trust, as a trustee and a grantor, I have full dominion and control over it for as long as I see fit.
That's right.
Once I'm dead, it becomes a irrevocable trust.
That's right.
Okay, good.
That's right. And so this is why the trust is sort of useful in estate and probate administration. A lot of people, well, there are a lot of companies out there that try to sell the product, do a trust to avoid probate. I don't think you can ever really avoid probate. There's always some type of process that involves the courts when you pass away. But what the revocable trust does do is it sort of helps ease the transition. Okay. And what do I mean by that? I mean, with the revocable trust, you have already identified a trustee, and that trustee sort of acts as an executor, if you will, executor or personal representative. You guys have heard of those terms. That trustee does the exact same thing with respect to those assets that are in the trust. And since those assets are already in the trust, and we're going to get back to this statement in a second, though, since those assets are already in the trust, the court doesn't deal with it. And so that's how you, quote unquote, avoid probate. But what you're doing is you're avoiding probate with respect to the assets that are relevant to that particular trust. Okay. So what does that mean? That basically means that you have to make sure that the assets you want in the trust are in the trust. Okay. So I usually, when I, work with my clients and setting up a trust, I usually send a memo to them. And I tell them that, the trust is no good if you don't put anything in it. Okay. So you can go to the lawyer's office, or you can go on LegalZoom now, right? And you can set up a little trust. You got the paperwork, you got your name in there looking all fancy. You got the trustee, name, beneficiaries, and you checked all the boxes and input all the information, and it spits out this great trust. And so you go tell your sister, girl, I got myself a trust. I'm good, right? But you haven't done anything with it. Okay. So in order for a trust to be effective, you got to do something with it. Okay. And what does that mean? What do you do? Well, it depends on what it is you're trying to put in the trust. So if you're trying to put in real estate, right, then you got to do a deed. Okay. You need to do a deed from yourself to the trust, and that deed has to be recorded. There's a whole process for that, right? If you have bank accounts down at Truist or PNC or what do you got, whatever you guys have, those bank accounts are in your name and not the trust name, unless you go to the bank, let the bank know that you have a trust set up and you'd like to set up a bank account for the trust. Well, then that means you got to get an EIN number, right? Got to do all the things that are necessary to make this trust work, make it workable and useful, right? So you have to actually put things into the trust in order for the trust to do what it is that you intend for it to do. And so what often happens is that, people, they're once they start the process. They will get the trust set up, and they may do that first initial thing, whatever that is. And maybe I set up a bank account and I got one bank account with my trust in it. Then they don't do anything else. So everything that's not in that trust, it's just not in that trust, unless you have taken the time to, again, work with the estate lawyer to make sure that your will and your trust all line up, and that anything that doesn't make it in the trust that you want in the trust, maybe there's language in the will that says anything not inside my trust goes into my trust, and then it, is divvied up and distributed this way. But again, I'm talking in generalities here. Every person's situation is going to be different, but it is very important to know that just having a trust is only the beginning. You have to actually fund the trust, is what we call it. That's the legal term for fund the trust. You put money in it, you put real estate in it, you put promissory notes in it, you put cars in it, you put whatever in it. Cars is a little complicated. I'm not going to go into that, but putting a car in a trust is probably not the best idea. But there are so many other things that you can put into a trust, but you actually have to take the steps necessary to do that. Okay.
I have another question, Brother Richardson.
Okay.
My question is, what course is taken if the trustee or the beneficiary dies before the person who makes out the trust?
Right.
And
So-
they're not old enough. I mean, they're up in years, unable to make some changes.
Mhm. So, like with any of these documents, again, we're not talking about the wills and the powers of attorney at this time, but the same is true for all of them. If you put any of these documents in place in year one, right, and you put it in your safe and you think everything is great, well, you need to take another look at it in year two, maybe in year three, maybe in year four, because just like you mentioned, things change. People pass. People, have incapacity issues. You name it. So what you try to do when you're first putting these documents together is you try to anticipate that, and so you say, okay, well, for the revocable trust, I'm the grantor and I'm going to be the trustee initially, right? But I'm going to identify someone who's going to take over as trustee when I pass, right? So there's going to be a successor trustee. Let's say John Doe. Okay, John Doe is going to be my successor trustee. Well, like you said, what if John Doe passed away and I didn't realize it, right? I may have an alternate trustee, okay, who's basically the third in line. There's me, there's John, and then my third alternate, okay? But man, COVID hit and he's gone too, right? Well, you can put language in there that gives somebody the ability to choose the trustee. So that goes into the nuances of how you prepare the initial documents, okay? And hopefully, if you've looked at the documents every year, you can make changes as needed. Okay, I need to update this to, put in a new trustee because this person is no longer able to do it, and you update your documents, then you can catch that type of situation. If you can't, right? If you can't, and what happens is if everybody who was in line to serve as trustee has passed on, then you go to the courts, and that's what the courts do. The courts are the place to fix that type of situation, and they would give as much respect and deference to the documents as they can, and try to appoint someone who would be in line. So if you have a will, a trust, and a power of attorney, then more than likely you've identified, someone to be an executor in the will, someone to be the trustee in the trust, and maybe someone in the power of attorney to be attorney in fact. The court may look at those documents to see if any of those people would be appropriate to appoint. And the beneficiaries at that point would probably have the ability to weigh in, because again, if the beneficiary has already been, identified, then the court is going to want to respect the beneficiary's decision and what's best for them, and appoint someone who may sort of act in their best interest. Okay, so that's when the court comes in. If everybody is gone or unable, then the court can rectify that.
Thank you, sir.
Mhm. Any other questions about that? About what a trust is, the differences between the revocable and irrevocable trust, and why
Just
we can do
a
it.
generic question for you, for those who may have come on late. Remind us where you are located, and I believe like these are all like specific. So like either you're in Virginia, or if you're in
Right.
Maryland, if you're in DC. So where are you if we want to follow up with you also?
Right. Well, I'm actually located in DC.
Okay.
Okay, I'm actually located in DC. And I've talked to a couple of the members, and I again, I'm doing this because I love Fifth Baptist. I love Fifth Baptist, and I love the Browns. I love Reverend Brown, and so I want to give the information as much as I can. I probably won't be able to represent many of you in putting these documents together. I do think it is important to have, when you're dealing with probate, I think it is very important to deal with a local lawyer. Okay, I really do think that's important because there are nuances, and Richmond, Virginia has nuances on how things are done. There are commissioners of account in Henrico and Richmond, and the local lawyers who practice before those commissioners on a daily basis, they know what needs to go into the documents to make sure that you avoid trip ups. Okay, so I think that's very important. So I'm not here necessarily to toot my own horn. I want to make sure you guys have the information, because I think it's important. Now, if you have a loved one in DC, please let me know, because I do a lot of this in DC, and I do know there are nuances there as well. But
my dad is in DC, so I'll actually follow up with you.
Okay, absolutely. It's what I was going to do. I was going to just go into a couple of the cases I've seen recently that sort of help people understand, from a practical standpoint of what we're dealing with. So I was hired by one family in DC. Their father, three brothers, their father passed away and left a valuable piece of real estate in DC. Or most real estate in DC is valuable at this point. Left a very valuable piece of real estate in DC, and he left a will leaving that property to the three brothers jointly. Okay, and so we set the administration up, followed the terms of the will, and then one of the brothers was like, "Look, can I take my portion and put it in a revocable trust for my children?" Okay, so what we did is we set up a two-part transaction, because again, the father who passed away didn't leave it to his trust. The father left it to him, so it had to go to him first. So we had the personal representative do a deed to the three brothers, and then right behind that deed, we had him transfer his 1/3 interest in that property to his revocable trust. He's named the initial trustee. He has a backup trustee, and he has a beneficiary in that for that matter. Okay, so it can be useful in life. Now he's I think he's in his 40s. And so again, it goes back to what I was saying. In the next year or two, he's going to probably want to take another look at that document to make sure that who he has named as his backup trustee is still available. And if that person is not, then he can modify the document and name a new trustee, just so things can continue to be smooth. The beneficiary is still alive, right? But if the beneficiary were to pass away, right, then he would need to maybe either rethink the trust, or he could revoke the entire trust. And as trustee, he could transfer that property back to his name individually. Okay. So there's so many different examples of where these trusts come into play prior to someone passing away. Now I think he did that. He had a blended family situation. So he thought having that revocable trust in place where he could identify specifically who he wanted to go, this particular property to go to. That was, again, very specific to him. He has other assets that aren't going to that person, and they're not in, those assets are not in the trust. Okay.
Mr. Richardson,
Mhm.
Are there any conditions that would require a lien to be removed from the trust?
That depends on why the lien is on the trust. Okay, so, when you're talking about liens, usually you're talking about there's a creditor trying to attach
Yes.
the trust. So again, when we're talking about revocable trust, while the grantor is still alive, okay, the grantor has to still treat his estate, his current property, right, as he would if he didn't have a trust. Okay, so if there's a big creditor out there and there's a lien attached, then you gotta how do you get a lien off your property anyway, right? You can bond it off, right? Or you can pay it off. There's only, only two ways I know. Or you could litigate and win, right? But if you get a bond, you can bond it off, and that means a surety company comes and they pay that creditor off. Either way, that creditor gets paid there, or you go into your nest egg and you pay the creditor off and release the lien. Or if it's an improper lien, then you have to go to court and get that lien released in a different manner. So the trust is immaterial there, okay? Because again, with the revocable trust, it's you're still alive, you're still vibrant. You're just trying to put in a document, put in place a document that helps you with estate planning purposes for the assets you currently have.
Okay, so with that same scenario, if the grantor is changed, does that affect the lien? If the grantor, for example, if Medicaid has a lien on the trust and the grantor is the person trying to get Medicaid, if the grantor is changed to another name or another family member, does that lien still remain in effect?
Well, I mean, the thing about a trust is, the grantor is the grantor. Okay, so because you can trace the property.
Okay, I got you.
You know what I mean? So if I put my 8-unit apartment building, which I don't have, but if I put my 8-unit apartment building into a trust, I'm the grantor. You just look at the land records, you can see who owned it prior to the transfer to the trust, right? So you're not going to be able to change the grantor. You can change the trustee, but you can't change. Yeah, you can't change that. And I had a situation recently. Well, I say recently, it's going on right now, where I was counsel to this family in setting up an estate for a person who died in the nursing home. And it was due to some errors in the nursing home. And the family had to set up an estate and then sue the nursing home on behalf of the estate. Okay. The nursing home settled. And somewhere in the process, I got a note from Medicaid that they were going to put a lien on the estate assets because of the Medicaid covering Medicaid covering the stay in the nursing home. Now we got that lien off because it just didn't make sense to make him pay for a stay where you caused his death. Okay, so Medicaid released the lien. And so that goes back to what I said. How do you get a lien released in any situation? You bond it off, you pay it off, or you litigate it off. That's how you deal with a lien, regardless of whether you're dealing with a trust or not.
Okay, thank you.
So I want to, on this slide, it says, will the trust help me avoid probate? I touched on this a little bit, but I want to be very, very clear that if anyone ever promises you that a trust will help you avoid probate, it simply is not a promise that can be made, okay? Because whether or not someone has to go through the probate process is determined at the time the person passes away, right? There's a snapshot that has to be taken of that person's estate at the moment that person passed away to determine whether or not a probate estate is necessary, okay? And so again, if that person who passed away had a trust and a will and had gone through all of the various steps to deal with all the insurance companies to make sure the beneficiaries are named in a certain way, looked at all of their bank accounts that are individually held and made sure that any beneficiary accounts are changed. If everything on the date of that person's death is inside that trust or identified in the will, you still might have to go through probate, okay? If everything is in the trust, you might be able to avoid the probate process. But usually, it's been my experience that there's always something that didn't make it into the trust or something that has to go through the probate process. So I'm involved in another situation where there's a will. It's very complicated. The will was very simple, but that will and a very complicated trust work hand in hand, okay? Before the person passed, none of the property was put into the trust, none of it. But there's a provision in the will that says if I die owning any property, that property is automatically transferred to my trust. Okay, that's called a pour over provision in the will. So what does that mean? That means that will actually acts as the grantor at the time of that person's death. Okay, so that person has forgotten or didn't get around to putting certain things in the trust, but really intended the trust to operate in a certain way. That provision, having that type of provision in a will can save a lot of hassle because that avoids all of that property going through the sort of the normal probate process. It now will go and be processed per the terms of the trust, okay? Now, so what does that mean? It's not probate, but the trust still has to go through the machinations of managing and administering an estate. And so I try to tell, don't get sold on things that are not going to save you time, okay? When someone passes away, whether there's a trust, whether there's a will, there's work to be done. There's a lot of work to be done, especially if that person has passed away, quote unquote, with what, like you said, with liens, right? Creditors and assets, real estate, maybe a blended family, where you have to, a spouse, gets a certain percentage, and children of a prior spouse get another percentage. There's still going to be work to do, even if you have a trust, which sort of outlines what has to be done. There are still steps that have to be taken to get that that work performed. Okay, it may be more streamlined than going through the court process, but there's still work that has to be done. Okay. Any questions about that piece? About trust being used to avoid probate?
Chip, we've got about 6 more minutes.
Okay.
I
So-
don't want to
so-
have you go backwards to the first section, but can you just
don't
give
mind.
like a 30-second answer on the power of attorney again, just to kind of differentiate? Just a 30-second.
Yeah, no problem at all. No problem at all. I tell people, both the will and the trust are in operation primarily after death, primarily. Okay, you're using the will, you're using the trust so that you can control what happens after you pass away. Okay, even though with the trust, there are some things you have to do while you're living. the power of attorney is only while you are alive. And that's really the main difference in that document, okay? When you pass away, the power of attorney has no force and effect, okay? There is an assumption that if a power of attorney is valid, the person who was granted that power of attorney is still alive, okay? So with the power of attorney, I grant this person authority to act on my behalf because I am incapacitated or unable to. And what we talked about last time was you can make it short, you can make it long, lengthy, etc. But that is the primary difference when you're talking about a power of attorney and its role in estate planning. It really doesn't really have a role in estate planning. It does have a role in estate management, because oftentimes, and we talked a little bit about this last time, is there's more to manage if you're incapacitated, but you're still alive, okay? So you may be, for whatever reason, you could have had a serious car injury, you could be in a coma, you could have, you've become demented, you're suffering from Alzheimer's. There's so many ways. I've seen all kinds of ways. A mental health break, you name it. In that instance, if a power of attorney was put in place before that event, right, before the incapacitating event, it will put in place a person who has the authority to manage your affairs and your assets, while you're still alive. Now, usually that person can't do a will for you, okay? But they can absolutely, if you want them to have authority to transfer certain money or whatever into a trust, you can give them that authority, right? So there are things you can do with the power of attorney while you're alive to make sure that if something happens and while you're still breathing, you want somebody in place to take care of certain affairs. And I know that's more than 30 seconds, but an extra 15 seconds is, we talked a little bit about the fact that you have healthcare powers of attorney as well, which are more specific for someone making decisions relating to medical records, end of life decisions, healthcare, doctor's choices, etc. It's not a bad idea to have a healthcare power of attorney separate from a regular power of attorney. That way you walk into a hospital and you're handing them a one-page document or two-page document. This is the healthcare power of attorney. I'm here. I've been authorized to make decisions or authorized to look at medical records through this power of attorney, as opposed to a power of attorney, which may be 10, 15 pages. Giving that to a doctor, they're just going to toss it, right? But the healthcare power of attorney, they understand it. They know that's put in place. But again, that's when you're alive, okay? And when you pass away, those powers of attorney have no force and effect.
Thank you.
Mm-hmm.
Mr. Richardson, can there be two powers of attorney, like for two individuals, two different? Okay.
Yes, you can have a power of attorney. I can give power of attorney to let's say David. I have a friend, David. Ricardo knows what I'm talking about. He's a math genius. Okay, I could give him a power of attorney to handle all financial affairs, right? Then I can have a separate power of attorney for something else, to someone else. I'll put somebody else in place as my power of attorney for other purposes. So you can, again, with any of these things, you can make them as simple or as complicated as your life requires. Okay, so it's not unusual to see someone who has the power of attorney to deal with business be separate from the person who is the healthcare power of attorney, who may be more in tune with the sort of personal needs of the person in care.
Okay. I also heard you say that you're located in DC.
Yes.
Are you able, or have you any affiliates here in Virginia, Richmond?
I don't have any affiliates, but I'll work on getting sort of a list of competent people to make sure the members of Fifth Baptist are taken care of. I wish I could. I just, like I said, I think it's very important for this to have some local help. Very, very important to have local help, because there are always these local nuances, and I just don't get down to Richmond to practice. Like I used to practice in Richmond. I moved to DC in '98, and I've basically been here since then.
Okay, thank you.
Mm-hmm.
Are there any more questions? Someone wants to put something in the chat room, or you may unmute.
Okay.
I have a question.
Okay.
Mr. Richardson, do you think it's a good idea to have a family conversation around this topic so that there are no surprises about the trust? Or should it just be closed?
I'm laughing because I've seen it all.
Okay.
And I've also lived part of it as well. I will say this, there are two approaches. There are two approaches, and I have seen the consequences of both. And I will say that you know your family better than I do. But I would say be honest with yourself and go with your gut as to how you think the family will take it. Oftentimes you'll have the matriarch or the patriarch decide that this is how I want things to go. I'm going to go to the lawyer's office, draft it all up, and put it in a box and not tell anybody. And when I pass away, everybody will be surprised, but at least I know that what I wanted exactly will happen. That's one way to do it. Some call it the scorched earth approach. But that's one way to do it. There's no hemming and hawing. That person has decided they're going to do it this way. They don't share it all. Now, it's always a good idea if you're going to name someone as a trustee to let them know, right? Or if you're going to name somebody as personal representative, et cetera. I think personally, it's a good idea to let that person know, hey, look, I've tapped you to be a fiduciary for me. And I hope that you would be willing to do it. That doesn't necessarily mean you have to share the documents with them initially. You could say, look, I set it up. This is the lawyer. They have the documents. If I pass away, call that lawyer. Okay. There's no right or wrong way to do it, but some families would take take it differently. Some would handle that approach differently, take it differently. Okay. The other approach is to call a family meeting. I know my father-in-law did this. He called everybody together, and he's got, my wife, her sister, and a brother, and he said, look, this is what I'm doing. This person is going to be the personal representative. This person is going to have this role, and this person is going to have this role. That's it. But he let them know, and it's his choice to do it that way. And then if anybody wanted to protest, they could protest. But again, I don't think there's a right or wrong approach. I think that you just need to sort of read the room. And take the litmus test of your own family, and surprises can come hard. I will say that though.
Thank you. I totally agree. Thank you.
Everyone, we thank you all so very much. Attorney Richardson, thank you.
Thank you.
And in the chat room, we've already had members who will be waiting, and when you can, we know you're busy. Get that reference of attorneys in the city or Henrico or Chesterfield to me, and we'll make sure Fifth Baptist gets it.
Absolutely.
Thank you, everybody. Have a good evening.
Thank you. I appreciate it.